Start. Para. Heard Mr. Gode, learned advocate for petitioner. Miss Kalra, learned advocate for respondent number 1. Mr. Mullah, learned AGP for respondent number 2. State and Miss Kulkarni, learned amicus curiae. For the sake of convenience, nomenclature of the parties in this judgment shall be as follows: husband as respondent number 1, wife as petitioner, petitioner's sisters as her younger sister, and the children as twin daughters. Petitioner is the mother and respondent number 1 is the father of the twin daughters. Application filed for access to the daughters by the petitioner has been rejected by virtue of the impugned order dated 25/9/2023. Para. Present writ petition was heard by me on 1/8/2024 and the hearing was concluded on 2/8/2024. It has been a shocking revelation for me while hearing this petition, though the challenge in the present writ petition is with respect to rejection of petitioner's application seeking access and visitation rights to the twin daughters. There are various hidden alleged controversies which have been argued in the course of submissions made by heard advocates for the private parties. Writ petition has been filed by the mother, that is, wife of respondent number 1, seeking custody of her twin daughters. This is so because every passing day in this case is severely detrimental, traumatic, and prejudicial to the right of the petitioner, whereas every passing day as the daughters grow old is beneficial to respondent number 1. The twist, or rather more difficult part, arises because of the birth of the twin daughters by surrogacy. Para. Considering the severity of the charges traded by both sides against each other by order dated 19/7/2024, Miss Devyani Heard Kulkarni, learned advocate and counsel practicing in this court, was appointed by me as amicus curiae to assist the court. Relevant facts for adjudication of the present writ petition are as follows. First, petitioner and respondent number 1 are legally wedded husband and wife, and their marriage is admittedly in subsistence. This fact is not in dispute. Second, their marriage was solemnized as per Hindu Vedic rites and rituals in Jharkhand on 28/11/2012. At that time, petitioner's age was 30 years and respondent number 1's age was 32 years. At present, petitioner age is 42 years and respondent number 1's age is 44 years. Post marriage, they both resided together as husband and wife at Mumbai. Petitioner failed to convince, naturally due to medical issues of both parties as averred in the petition. Hence, they consulted a gynecologist, and it was diagnosed that eggs of the petitioner were non-viable. Their gynecologist advised them altruistic surrogacy through an egg donor. Petitioner approached her real younger sister to be the egg donor, to which her sister agreed. The sister was herself married at the then time and had one daughter. The produce was carried out at Kiran Infertility Center, where parties entered into a surrogacy agreement dated 30/11/2018. Both parties have vehemently commented on the said agreement and I shall advert to that latter in my observations and findings. IVF treatment commenced in the month of December 2018. At the then time petitioner was employed, petitioner's sister donated her eggs sometime in January 2019. Surrogacy procedure commenced thereafter with the surrogate mother. On 21/4/2019, the sister, her husband and daughter met with a road accident on Agra Expressway, leading to demise of her husband and daughter. Petitioner's sister, that is, the egg donor, survived but met with disability. On 25/8/2019, twin daughters were born through surrogacy to the surrogate mother at Kiran Fertility Center. The period thereafter is being narrated conversely by both parties by slinging allegations against each other, which I shall consider cursorily at the time of recording their respective submissions. From August 2019 to March 2021, petitioner, respondent number 1, and their twin daughters resided together at Navi Mumbai. Due to issues between parties on 25/3/2021, respondent number 1 moved along with the twin daughters to Ranchi, that is his native place, without informing petitioner when she was at work. Stop.